This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're talking about what happens when an insurer fails to tender a settlement promptly and finds it must be penalized under state statutes, and why statutory penalties, however, must be based on evidence, and without sufficient evidence, a penalty assessment was found by the Court of Appeals of Louisiana to be wrongful. When an appeal involved issues concerning the statutory penalties that apply to an insurer who knowingly or arbitrarily fails to pay a settlement to a third-party claimant within 30 days after a settlement agreement is reduced to writing, the plaintiff, James Bridges Sr., settled his claims arising from an automobile accident for $450,000. The trial court found that the settlement amount was not paid timely and applied Louisiana Statute 22-1892 to the penalty claim, imposing a penalty of $225,000 on one of the insurance company defendants. The insurers appealed. In James Bridges Sr. versus Chubb Indemnity Insurance Company and others, the Louisiana Court of Appeals on July 2, 2025, dealt with what appeared to be an excessive penalty for failing to deliver payment within 30 days of settlement. The defendants appealed the judgment, raising 5 assignments of error concerning the amount of the penalty and the sufficiency of plaintiff's proof. James Bridges alleged that he was injured in an automobile accident caused by Deidrick Green's negligence. Bridges settled his claim with Green's employer, and their alleged liability insurers for $450,000. The settlement agreement required payment within 30 days of defendant's receipt of signed release and final payment letter from CMS. He did not assert a claim for any damages sustained as a result of the late payment of the settlement funds. The trial court found the plaintiff had met the burden for several reasons, all of which are clearly based on, quote, facts, close quote, presented solely in the supporting and opposing memoranda or in argument of counsel. The trial court found that the failure to pay the settlement timely was arbitrary or without probable cause, and imposed a penalty of $225,000. The facts, which were not presented in the form of competent evidence, caused the trial court to conclude that the delay could easily have been avoided, and therefore it was not justified or reasonable, and issued a judgment against Chubb for half of the total settlement amount and $1,500 in attorney's fees. The only evidence that was submitted at the penalty hearing was Bridges' evidence proving that the conditions of the settlement agreement were met. Bridges did not introduce any evidence proving that the settlement payment was untimely or that the delay was arbitrary, capricious, or without probable cause. Here, the trial court found that Bridges met his burden of proving that the settlement payment was untimely because there was no dispute that there was no payment made within 30 days after it became due. However, the record did not support the trial court's conclusion that Bridges met his burden of proving facts establishing the entitlement to a penalty under Section 1892. When the settlement includes property damage and medical expense claims, along with other types of damage claims, as it did in this case, the amount of a penalty awarded under Section 1892 may not exceed 50% of the amount of the settlement attributable to the property damage, and reasonable medical expense claims are $1,000, whichever is greater. The appellate court concluded, therefore, that the trial court's broader interpretation of the statute was contrary to the statute and to Louisiana Supreme Court directives, and therefore the trial court was ordered to render its decision based on real evidence properly before it for consideration in the interpretation of the penalty provisions of Section 1892 set forth in the appellate decision. In my opinion, there is usually no logical reason for an insurer to fail to pay an agreed-upon settlement in more than 30 days from the settlement for reasons never brought to the trial court or the appellate court. Chubb failed, and by statute must be penalized for that failure. The trial court assessed, however, an excessive penalty based on a lack of evidence from the parties. So the Court of Appeal made the trial court reconsider based on actual evidence and the court's interpretation of the statute. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the link provided and on the URL zalma.com/blog. You can subscribe to my blog at any time, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll also have access to the more than 5,100 blog postings. Please tell your friends and colleagues about this blog so that they too can subscribe, and also subscribe to these videos on YouTube and rumble.com. And if you watch the videos, please click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing to my Substack publications for a very small fee. Thank you for your attention.